another effort to dismiss a lawsuit from major cannabis companies seeking to block enforcement of prohibition against state legal activities, the Justice Department may have made the best economic argument yet for those in support of federal legalization, that it boosts travel tourism revenue. Marijuana Woman's Kyle Yeager reported that the argument was made in a filing with the U.S. District Court of District of Massachusetts, Western Division on Friday, where the Department of Justice contested claims from cannabis corporations that federal policy is at odds with the government's enforcement practices. And it also argued that the plaintiffs lack standing to raise the lawsuit in the first place. The Justice Department argued in the filing that plaintiffs argue that federal marijuana policy no longer serves as a goal of eradicating marijuana trade, yet even if that is true, curtailing the marijuana trade is legitimate objective regardless of whether government pursues the objective to the point of eradication. Plaintiffs also cannot show that in any way in which federal marijuana policy is irrational when they allege that federal policy focuses law enforcement resources on marijuana activities that must implicate vital federal interests, such as preventing violence and protecting public safety, it added. Word salad, word salad, word salad. The underlying suit against the federal government is being led by Verano Holdings Corporation, an MSO, and Massachusetts-based businesses Canna Provisions and Wiseacre Farm, along with Trevit CEO Yassi Sellers, who is the I guess the face of the lawsuit because he's a social equity applicant. Get in deeper into that. But Yeager notes that the DOJ said in the latest filing that the plaintiffs lack jurisdiction in the suit, partly because they cannot establish a credible threat of future enforcement of the Controlled Substance Act when they allege that the Department of Justice has a policy not to prosecute their alleged conduct. And because they allege that the Department of Justice adheres to a policy of not prosecuting those who engage in plaintiff's conduct, they cannot establish a credible threat of future enforcement. He also says the DOJ makes several notable admissions in the latest documentation. For example, it contests the idea that plaintiffs are harmed under prohibition because it has resulted in the reluctance of banks to work with the intrastate businesses, pointing out that the department has not taken to coerce any of the third parties who have declined to transact with the plaintiffs. And they do not and cannot dispute the complaint that the complaint alleges that some third parties have decided to transact with the plaintiffs while others have declined to. The department also asserts that lower court does not have jurisdiction to undermine the 2005 Supreme Court decision Gonzalez versus Raich, listen to this one, in which justices held that state-level cannabis laws do not protect people from federal prosecution because the Congress has interest in preventing illegal marijuana from entering interstate commerce. Here's what they said. Raich's constitutional holding is controlling here because the Supreme Court is the only court with the power to overrule its holding in Raich, which would be necessary to sustain plaintiff's Commerce Clause and necessary and proper clause claim. Even if Raich's ultimate holding were not directly controlling here, the CSA's application to plaintiffs falls well within Congress's authority under Commerce Clause and necessary proper clause. Plaintiffs do not and cannot dispute that the Supreme Court's case law under these clauses firmly establishes Congress's power to regulate purely local activities that are part of an economic class's activities that have a substantial effect on interstate commerce, end quote. So part of their reasoning here is that it claims that it is rational to conclude that the regulated industry in Massachusetts fuels a different kind of cannabis-related interstate commerce, marijuana tourism. That is especially so because Massachusetts marijuana businesses gross hundreds of millions of dollars in sales each year, and dispensaries such as Canna Provisions cater to out-of-state consumers. In other words, while the plaintiff's claim is that the Constitution's Commerce Clause should preclude DOJ from interfering in state legal activity because it's centrally regulated within the state's borders, legalization attracts cannabis tourism from people from states without legal programs who would prefer to buy from regulated storefronts. So, It's a lot to unpack here, and there's much more to the story as told by Kyle Yeager's excellent reporting here, which can be accessed at high9news.com, along with a live link to the filing in its totality. But I think that the DOJ is digging themselves deeper into a hole daily with these regional lawsuits that they've been exposed to, and is also exposing the division between state laws and federal enforcement. Whether it's banking, the right to bear arms, or vital tourism revenue, in each of these taxpayer-funded cases, they're looking more and more like dicks, more concerned with meddling in state-run affairs than actually protecting the citizens paying their salaries. I don't know how much more time we've got until great Uncle Joe Biden's federal D or reclassification bonanza kicks off, but I'm sure at this point the DOJ is siding with the rest of us and thinking it couldn't be over soon enough. My name is Rico Lamite, the dopest dad on the street for High 9 News. What y'all hear? What y'all think about this one? DOJ gonna lose again?
Oh man! Oh man! This is a very interesting argument that they're posing.
Taking money out of local business pockets.
Yeah,
and they're just looking more and more like the bad guys.
I feel like they're arguing against themselves right now.
They are.
It's like
it's good to see.
I mean,
I love seeing it.
Man, is this an apocalyptic argument, Rico?
Stop pushing these conspiracy theories, man. I'm not going.
It was up on Twitter and Rumble all night.
On Rumble, True Social. I'm sure he bought plenty stock in.
That's the one.
Ride that thing down to the ground.
Yeah. Stock is going up today. It's going up. I'm really curious as to hear what Yaro's opinion on all this.
Well, I'm not a lawyer. I don't play one on TV.
Mm-hmm.
I think that it's, I got a couple little sort of things I guess I could opine on. The first is it is nice to see the resources from well-heeled MSOs being used to push back and to hopefully create a future, a near-term future where there's a more coherent policy. MSOs typically get demonized because they're not usually supporting the small mom and pop operator or cottage cultivator. This might be a bright light where they can afford to push the issue and create some substantive change. The other thing that comes up for me is they hired like the ninja of lawyers. I'll mispronounce his name, but this David Bowes. This guy's
David
like
Boyce.
The real deal. I mean, this ain't no Better Call Saul. This guy is like
No. David Boyce is a top-notch lawyer. I've had a few meetings with him over the years, and this guy is the real deal.
He is the real deal. The other thing is that it says, look, you can't challenge something in the lower courts that's already been decided by the Supreme Court. And because I'm not a lawyer, I don't know if that's accurate. Because on the one hand, it is already decided by the highest court in the land. On the other hand, typically changes that are created at the Supreme Court level are a result of things bubbling up from the lower courts and then subsequently needing to be decided by the Supreme Court. So I'm not entirely sure that argument holds merit. And then for me, the bigger picture is just that we still have these massive issues between federal and state law. And this is yet another symptom, another example, another thorn in our side, because we don't have congruence between what is allowed on a state level and what theoretically we should sort of figure out how to conform federal laws to allow for these state programs. And so there's a world in the near future where interstate commerce is actually really, really beneficial for cannabis programs. As new states come online, as new states add on an adult use market, as new states don't have the production capability to keep up with their constituents, it would be balancing supply and demand to be able to have lawful interstate commerce. And hailing from Northern California, I like to think that allowing for the passing of cannabis across state lines would also benefit the historic, prolific producing regions that have the human know-how, the genetics, and the appellations to be able to create great cannabis that could be enjoyed by all Americans. So I'm hopeful that the plaintiffs prevail. because I'm super biased.
Yeah, no, I'm with you. I'm on the plaintiff side too, and I am surprised that this is an MSO that is putting their money on this, but I do think that is the best thing for the industry to try to slow this thing down. So I feel a very similar way as you on this, Yarrow. Any thoughts on this, Matthew, before we move on?
I'm with Yarrow's perspective. I think he hit the nail on the head. It's just funny to watch the federal government talk out of both sides of its mouth. Like, oh, we're not making things difficult. We're not doing anything. Banks,
Yep.
Banks are frightened because they're patrolled by the SEC, and these folks, these CEOs and stuff that run these banks, don't want to do 25 years in federal prison for working with Schedule I drugs. So it's definitely the federal government that's causing the holdup with this whole thing. Just be nice for one folks in the federal government.
Fair enough. And on that, we're going to go to a commercial. We're going to be right back.